Hello, welcome to Learning Law and this Company Law Part 6. We are going to discuss about shares. In this, shares, allotment, share certificate, transfer of shares, forfeiture transfer, call on shares, forfeiture of shares, surrender of shares, lein on shares, and dividend on shares. What is share? Section 2, Clause 84 of Companies Act 2013 defines share as share means a share in a share capital of a company and includes stock. It can also be said that share is just a paid securities. Shares are issued by companies to raise money from investors who tends to invest their money. This money is then used by the companies for development and growth of their business. What are the kinds of share capital? Equity share and preference share. Equity shares are shares which are not preference share capital. All other share capital which are not preference share or equity share capital, and the proportion of company's money which is raised in exchange for a share of ownership in a company. Then what is an equity share means? It's different from shares other than preference shares are equity shares. Now let us see what is preference shares. Preference shares are one of the special type of share capital having fixed rate of dividend. They carry preferential rights over ordinary equity shares in sharing of profits and also claims over assets of the firm. People who buy preferential share capital get priority in dividend declaration, and at the time of winding up they are the first people to receive money. They have right to vote only when the matter directly or indirectly affects them. Then what is the difference between equity and preference share is? Equity share owner has the voting rights, and preference share owner not always have voting rights. When the matter directly or indirectly affects them, he has voting rights. And in times of preference share, dividend are fixed. They are fixed rate of dividend and that shall be paid. And in equity share, the dividend will differ based on the profits of the company. So these are the differences between equity and preference shares, and on winding up, preference shareholders will get first preference to receive money. Share certificate section 46. It's a document that certifies the fact that a person or an individual is the owner of a certain amount of shares. It is issued under the company seal signed by two directors, a managing director and a company secretary. It is a prima facie evidence of title. It acts as estoppels to the title and estoppel as to payment. And it is a share certificate is a conclusive proof that a person is holding this much of share and he is this percentage of ownership. He is holding this percentage of ownership in a company. Allotment of share. An allotment to be effective has to comply with the requirements of law of contract relating to the acceptance of an offer. Conditions for valid allotment are allotment by a proper authority. The share should be allotted by a proper authority within reasonable time. It should be mentioned in prospectus or any other articles of association. Must be communicated to the applicant. An absolute and unconditional share should be issued. Then such allotment is valid. Issue and allotment. Public company must issue prospectus. A company which should issue prospectus for issuing of shares. Interested can apply after looking into the prospectus. Minimum subscription should be paid as mentioned in the prospectus. Without paying of minimum subscription, share cannot be allotted. Share application amount should be deposited in the bank, and company has to return and refund the entire subscription amount instantly if 90% of the issue amount is not achieved within 60 days. For further delay beyond 78 days, the company has to pay 6% interest per annum. Call on shares. After allotment of shares, the company can call for full amount or part which are due on shares from the shareholders according to the rules mentioned in prospectus. Usually, the articles of company includes provisions regarding the call on shares. If it is absent, then the following are applicable. If a person buys a share from a company and the rate price amount, that is the value of share, is 100 rupees, and he is paying 50 rupees at first, and that is called as paid up share. He is paid 50 rupees and his remaining he has to pay is another 50 rupees, and the company can collect that 50 rupees from that buyer, the person who is holding share, on calls that may be fixed by prospectus or articles of company. The procedures are fixed by the prospectus or articles of company. If there is no such provisions in articles of association, the general provisions which are applicable are: no call should be for more than 25% of the nominal value of each share. The interval between two calls should not be less than a month. At least 14 days should be provided to each member for call mentioning the amount, date and place of payment. Call should be made on uniform basis. and a company should make a call to the shareholder to pay the amount, and that amount should not exceed 25% of the nominal value of each share. The interval between two calls should not be less than a month. And these are the procedures, general procedure that has to be followed if there is no provisions regarding the call on shares on articles of association. Forged transfer. Forged transfer of shares is always considered to be a nullity, and the transferee does not obtain any title to such shares. If a person forgedly transfer shares to his name from the original owner, then the transferee does not gain any ownership. The original owner always has the ownership, and the forged transfer will always considered to be a nullity. The original owner never loses his rights of ownership and is considered to be a real owner despite the transfer taking effect. Forged transfer or any bona fide transferor cannot be the owner of shares, and the company is bound to pay the dividend to the original owner if pending, and the company is bound to restore the title of the original owner on call on shares. If there is a forged transfer and the company mistakenly uh, type, uh, remove the title of the original owner, then the company is bound to restore the title of the original owner on shares if there is a forged transfer. Transfer of shares. Section 82 empowers every shareholder to transfer his shares as the provisions laid down in the articles and in accordance with the various provisions of law. A share transfer is a process of transferring existing shares, that is rights and liabilities, from one person to another. A company shall not register transfer of securities of company or members' interest in company other than beneficial owners without a proper instrument of transfer within a period of 60 days from the date of execution. And shares of a public company are freely transferable. The shares of public company are freely transferable unless a company has a valid reason to disallow the same. There may be certain restrictions on transfer of shares of private company. In case of public company, shares are freely transferable. In case of public company, shares are freely transferable. In case of private company, it can have certain restrictions on its articles. Forfeiture of shares. Forfeiture of shares is referred to as a situation when the allotted shares are cancelled by the issuing company due to the non-payment of subscription amount as requested by the issuing company from the shareholder. In the event of forfeiture of shares, shareholder loses the rights and interest of being a shareholder and ceases to be a member of the organization. The company forfeiture the share in times of non-payment from the shareholder. That is, on call the shareholder fails to pay the subscription amount, then the company can forfeiture the share. In times of forfeiture, shareholder loses the rights and interest of being a shareholder in a company. He does not have any rights and interest after forfeiture of shares in the particular company. Surrender of shares. Surrender of shares means surrender of shares already issued. Okay, if a company issues shares and the shareholder voluntarily surrenders his shares to the company, in this situation also the shareholder loses his rights and liabilities in the company. Surrender of shares is a shortcut procedure in order to avoid the forfeiture of shares. It's generally used as a shortcut procedure to avoid the forfeiture of shares. Shares that have the possibility of being forfeited due to the default in payment can be voluntarily surrendered up by the shareholders. Lein on shares. The right of lein is on all shares that are registered in the name of member for all debts, liabilities, or engagement to or with the corporation by him. If a person who is the shareholder having debt, liabilities, or engagements with the corporation, then the company has a right to lein on shares. The company's lein on shares exists also for debts due by the shareholder to the company in capacity as a customer of company. Dividend on shares. Section 2 Clause 35 of Companies Act 2013 defines the dividend as the specific portion of profit given to the shareholders from the net profit of the company. In other words, dividend means a portion of profits received by the shareholders from the company's net profit. Preference shareholders have priority on payment of dividend over equity shareholders. As we already saw, preference shareholders rate of dividend is fixed, and equity shareholders dividend is based on the profit of the company. So the preference shareholders have preference for payment of their dividend than equity shareholders. Thank you for watching this video.